Okay, Shannon, you can put us on the record now.
Okay.
All right, this is a matter of Frank and Tammy Myers versus Linda Hale. Mr. Brian Hilderly for the plaintiffs, Ms. Rebecca Kerr for the defendant, and it looks like all parties are also present. So, Ms. Kerr, this is your motion for summary disposition, I believe, based upon the amount in controversy. Mr. Hilderly's complaint, though, pretty clearly raises a complaint for specific performance, which I think is within the jurisdiction of this court, irrespective of the amount in controversy.
Correct, Your Honor, and we did file a supplemental brief with regards to the specific performance that appears to be the remedy requested under the court's equitable jurisdiction, wherein we assert that, and so our motion had originally indicated not only under the jurisdictional grounds, but also under the grounds that they're requesting relief that their request is for relief that cannot be granted, and this is specifically because of the request for specific performance and the fact that it would be inequitable, just based on the information that they have in their complaint and that we have in our motion for summary disposition. We're requesting that the court exercise its discriminatory. It has discretion to decide whether or not to grant specific performance. It is not a performance by right, and therefore it's not a remedy by right. And so we're asking that this court exercise that discretion to not grant specific performance because of the facts in this case, specifically that under their own purchase agreement, they claim that there was an agreement to purchase these Kentucky properties as well as the Michigan property, whereas the purchase agreement was not provided to my client. And furthermore, the amount that was paid for the Michigan property alone was $25,000. Title insurance was only purchased for the Michigan property. Essentially what we're claiming and what we feel the documents indicate is that they're asking this court to enforce a gift by my client to the plaintiffs of the Kentucky properties, and that there was never an agreement. My client has never discussed with them or agreed to sell any properties in Kentucky to the plaintiffs. And yet they're putting it into a purchase agreement under the claim that now it needs to be asserted. Everything else has already been transacted.
Let me stop you, because the only things that I am getting some feedback from somewhere. I'm not sure what the source is. So your supplemental filing has not made it to my chambers. All I saw prior to coming out on the bench today was your initial motion and Mr. Hilderly's reply.
Okay, yes, I apologize. It was filed with the court, and it was served on Mr. Hilderly by email as well as in mail, and it was filed with this court, I believe, a week ago or maybe even longer.
Well, if it was a week ago, I don't think it's fair to Mr. Hilderly. A motion for summary disposition has to be filed and served with sufficient advance time to allow the defendant to file a response. If you file a supplement to the motion that raises entirely new grounds as a basis for the motion, I think Mr. Hilderly is entitled to a little more time in which to respond. So I doubt that I'm going to be able to rule on this today, but let me ask, because one of the arguments you made, Ms. Kerr,
yes,
was that the Kentucky property was supposed to be a gift and wasn't part of the agreement between the parties. I've got an agreement that appears to bear the signatures of Linda Hale, Frank Myers, and Tammy Myers, which I believe are the parties to this lawsuit and the parties to the purchase agreement. And I'm looking at paragraph 1 of that purchase agreement. It says seller agrees to sell and convey to purchasers, and purchasers agree to purchase from sellers real estate on Pomeroy Road, Jackson, Michigan, in the township of Sandstone, Jackson County, Michigan, and 2 real estate parcels in Magoffin County, Kentucky, together with all buildings and improvements thereon, for the sum of $25,000.
Yes,
So
Your Honor, that
if
is
the bid-
indeed what the purchase agreement that they've proffered to the court is the agreement of the parties. That is what they put in their complaint and what they attached to their complaint. However, that was not my client never received a copy of the purchase agreement. She's not certain if that is indeed page 2. There's no dating or initialing on page 2 to indicate that those Kentucky properties were supposedly included in this purchase agreement. But the purchase was always specifically for the Michigan property. If you look at the rest of the information and the fact that it was conveyed for $25,000.
Let me stop you.
Sure.
So, if there's some kind of a claim that pages were fraudulently substituted for the pages that she signed, it sounds to me like there's going to be a factual dispute here. How can I possibly resolve a factual dispute as to what is or isn't within the agreement of the parties at this stage of the proceedings? So the reason I'm jumping ahead is I can't rule on it today with certainty. I can tell you that because I haven't even got your response. But as I look at it, it appears to me that there are questions of fact here that are going to have to be sorted out.
And I understand that, Your Honor, and I appreciate that. And if you feel that we are premature in our motion, I'm still very confident on the facts that, and we feel that what we've submitted to the court, though you don't have it, unfortunately, because there was also a closing agreement that was attached to my supplemental brief, which I think would make it more clear. But the deed that was presented by the plaintiffs alone in their pleading clearly shows that any conveyance of land was to be a gift by my client with regards to the Kentucky properties. And that alone shows there was no consideration for anything that they're asking you to now enforce as a contract of purchase. And my client had never agreed to sell anything from Kentucky to the plaintiffs. So, and their own deed shows that fact by saying that it's strictly a gift for the conveyance, and that and the full amount was actually executed on the contract. And that was part of the original and indicated to you that the warranty deed was for $25,000 consideration just for the Michigan property. And that was what the intent of the parties was at the time, was to sell the Michigan property for the $25,000.
All right, well, let me give Mr. Hilderly a chance. It would appear to me, Mr. Hilderly, that even though I haven't seen the actual supplemental brief, Brian, I think the feedback is coming at your end.
Oh, really?
I'm not every night, because I just heard the feedback and your image lit up, with the gold bar around it. That usually says where the sound is coming from.
Okay, do you want me to mute mine for a second, or do you want me to just address?
Just address.
Mute yours for just a second. Let me say what I'm going to say, and then I'll give you a chance to respond. Okay, so even though I haven't seen what Ms. Kerr is representing that she filed, and I don't doubt that she did, mail has been moving incredibly slowly. Plus, stuff that arrives at the courthouse clerk's office today doesn't necessarily make it up to me today. So there's reasons why I might not have gotten it. I don't doubt that she filed it. But in any event, based on what she's telling me is in it, it appears to me that at a minimum, we have some questions of fact here that are going to have to be ferreted out with an opportunity for discovery. So my inclination is to deny the motion today without prejudice. I mean, I can certainly deny it based upon the initial claim that it's not within my jurisdiction. But as to the supplemental, simply deny it without prejudice to refiling it once the parties have had a chance to do some discovery. So go ahead and speak, Brian.
Thank you, Judge. So fundamentally, I agree. The original motion under C4, certainly, I think Ms. Kurz is real. And again, in my response, I took some responsibility. Maybe I didn't make it as clear as I could have. That certainly what we're seeking is not money damages, and it is specific performance. So I think we all agree that that would be within the jurisdiction of this court. When I did receive Ms. Kerr's supplemental response, I did not respond to it because I didn't feel there was a need to respond to it for the reasons that you've stated. She filed it under C8, which is really basically saying that even if you take everything true in our complaint, we still couldn't win. She's not saying that. She's not saying we can't win. She's saying we shouldn't win because of these reasons. Now, ultimately, we'll see. I mean, the facts have to be developed, as you said. So I think as far as C4 and C8 go, I don't believe we've certainly stated a cause of action upon which relief could be granted. Whether it should be granted will be up to the court. So I think for purposes of C8, I agree it should be denied. If at the end of discovery, she's able to establish and show that there are no questions of fact, she could file a C10 motion at the conclusion of discovery. But I think ultimately what the court is going to see is we'll have some questions of fact that will have to be sorted out at a trial, and and have the ultimate decision happen after a trial. I don't believe there will be a way to for either side to win on a C10 motion. So I agree. I didn't file a response to the C8 part of it because really all the court does is look at the complaint for a C8 motion. So I was comfortable that we pled a cause of action where we could receive relief. And in reading her motion, it like she said, she's attached other documents to her motion for C8 when the case law says you only review the pleadings. So it's, again, I think for our purposes today, as far as C4 and C8 go, I agree that it should be denied. If you want to do it without prejudice, that's fine. I don't think she'd be able to file a C8 down the road, but that doesn't, whether she does or she doesn't, it doesn't bother me. I would say that it would most likely be a C10 motion if she ever filed it again. So that would be my position on it as well. I don't need any time to respond to her. I understand if Your Honor obviously would like to review it before you make a decision. I don't need any time to respond. I did have a chance to review it. It is a motion filed under C8, and I believe that the court will see that we did file a complaint where relief could be granted under certain factual circumstances.
All right. So it makes what I said. It makes sense. Then I will deny the C8 motion based on jurisdiction. to the extent plaintiff wishes to renew a C10 motion after some or defendant chooses to raise a C10 motion after some discovery. Obviously, this ruling today is without prejudice to that. The only other question I want to ask both of you is, it certainly does appear to me a bit unusual that you're asking me to specifically enforce the conveyance of property that's located in another state. And I simply raise the question. I don't want to make stuff more costly for the parties, but I think at some point we need to address whether I have authority to compel conveyance of property that's actually located in another state. But I'll leave that for another day.
Your Honor, I can just briefly touch on it if you want.
Go ahead.
We certainly considered that when I looked at where we should file this. The parties are residents of Michigan. The contract was signed in Michigan. And what we're asking you to do is, while it does affect property in another state, it's really a Michigan resident. And what we're asking you to do is force her to honor the contract. So we saw it more as a breach of contract case between Michigan residents than necessarily, obviously, if it was something more related to the property itself, some sort of an easement or, something like that, I would understand. But because it really doesn't have anything to do with the property other than what we're really asking is for enforcement of that contract.
All right. So if we could get an order submitted reflecting my ruling here today, and we'll leave these issues for a future day, the remaining issues. Ms. Kerr, you'll submit that order?
Yes, I will prepare and submit that order, and we appreciate the court's time, and I will have my answer and affirmative defenses filed. What do I get, 15 days? I just want to confirm that I'm within the time.
Yeah, well, is 14 days sufficient for your sake?
Absolutely.
I'll allow an
days.
answer to be filed within 14 days of today's date.
Thank you.
You're welcome.
Thank you, Judge.
Have a good day.